Okie dokie.
Chris, do you want to go first or do you want me to go first? Because I don't see an order.
Mr. Chairman, I like both bills. If you want me, I'll go ahead and go first and get mine out of the way, and we'll have yours.
Okay, that'll work. Are we live, Denise?
Yes.
Good afternoon, everyone. I'd like to take this opportunity to welcome everyone to the House Economic Matters Committee. Today is Friday, January 15th. We have but two bills before us today, House Bill 395, as well as House Bill 408. They are, the subject matter is similar in nature, but there are somewhat significant differences. We're going to go with House Bill 395 first, Delegate Adams, and then we'll follow with House Bill 408. With that, Delegate Adams, you're up.
Okay, thank you, Mr. Chairman, and Madam Vice Chair, I see you with us this morning, or this afternoon. Thank you, and thank you for the opportunity to present House Bill 395. This is a bill that's been brought a few times before the committee. Delegate Warren brought a bill that was submitted to be this bill. We got it through the House in 2017. It did not go through the Senate that year. The House passed this bill, I think, in 2018 or 2019, and it did not pass the Senate. It looks like to me we have a similar bill with the chairman that does a similar thing. And I think it's good that we are having this discussion, because ultimately what this is about is helping contractors at the outset of a construction project to get sufficient cash flow to begin work. Last year, when I brought this bill in the testimony, I talked about how 33% down doesn't cover cost of our goods. And the exercise of being a responsible contractor ultimately comes down to cash flow, keeping costs down, obviously performance, which the Attorney General has some opinions on. But at the end of the day, the polite ask is to increase the percentage from 33% to 50% and better help contractors cash flow their projects. I'll simply close, Mr. Chairman, because this is a bill the committee's heard a few times, as I've done in years past, where I'd like to just briefly address the Attorney General's remarks. And I understand that there are contractors that aren't doing the right thing, and they certainly are the subject of this commission and the work that they do, the good work that they do. Ultimately, however, I believe most contractors are honorable, honest card holders like me. I've got my MHIC license here. We know how to do the right things, and we are trying, especially in this year, to manage our businesses, manage cash flow, and getting work done. I believe the bill goes very much. I believe my bill goes a long way towards helping contractors, and I'd ask the committee for a favorable report. Thank you very much.
All right, Bob, hold it down back there. Any questions of the sponsor? Remember, guys, if y'all do, let me know, because I'm flying blind a little bit. So I'm going to take that as no questions for Delegate Adams. Thank you, Delegate Adams.
Thank you, Mr. Chairman.
Mike O'Halloran.
Yes, sir. Good afternoon, Mr. Chairman, Madam Vice Chair, members of the House Economic Matters Committee. It's great to see you guys again, albeit I wish I was down the street seeing you guys in person, but the fact that we all need to stay safe and healthy, that's paramount. I want to thank, for the record, Mike O'Halloran, State Director of NFIB Maryland. I want to thank the sponsor, Delegate Adams, for bringing this bill before you. As he mentioned, it did pass the House Chamber in 2018 overwhelmingly, 133 yes votes to only 2 negative votes. One thing I do want to touch on very briefly, because you guys should have my written testimony in front of you, so I don't want to belabor the point, but with regards to the concerns about the Attorney General, look, the remedies to any issues that a client may have with a contractor are still available to them. They can still go through the Maryland Home Improvement Commission. They can still go through the Attorney General's office. So we're not touching that at all. And, you know, we are willing to admit as well that, yes, there are unscrupulous contractors out there, but however, the overwhelming majority of home improvement contractors are doing the right thing because frankly, they want to stay in business. They want to keep customers coming in. So by moving this from 33% to 50%, as the sponsor pointed out, cash is king and cash flow is ever important, particularly now when we hear, you know, just from my own personal experience, having done a home renovation over the last year, you know, the cost of goods and materials is going up. So allowing contractors to have that extra cash on hand to get the materials that they need, hire the subs and so forth that they need to complete customer's project, we need to do that. So again, I appreciate the sponsor bringing this forward again this year, and we ask for a favorable committee report.
Any questions of Mr. O'Halloran? Mike, your space looks like mine did yesterday. We got to get you a light too.
I have a window right here, and it's just don't have enough light coming in, so I got to.
I looked like that yesterday. All right. Any questions from Mr. O'Halloran?
I do have one.
Delegate Impalaria.
Yeah, so previously the way it worked, it was a third at writing the contract, a third at starting the job, which would be 60%, and a third when the job was completed. How will that work now? What would you're saying 50%? That means they're going to get 10% less at the start of the job. Is that what you're saying? There's a 50 and 50?
Well, so here's the thing: is that this bill is just enabling. You know, contractors, and I'll expound upon this more on the chairman's bill. Contractors, you know, can go about any way they want the installment plans, and that's up between the contractor and the customer to negotiate a payment plan. So, you know, again, this is just enabling legislation. But to your point, you know, if I'm a contractor and I ask you, you know, I have a contract with you, let's say to put down flooring, and I ask for 50% up front, you know, and you accept those terms. The other payment, you know, the rest of that could be, well, you know what, you give me 25% when I get done putting down the subflooring, and then the final 25% when I put down your hardwoods and the job is complete.
So you're saying is that it would be 50% writing the contract, and then it can come back and there's no limit to what the second percent was, because it was a hard 33 and a third, 33 and a third, 33 and a third is the way it was. So this would be 50%. What are the limits for the second payment and the third payment? Or is there no longer a second pay? You're saying negotiate, but the actual law was a third, and a third.
So that's not exactly right. The current law is the initial deposit is up to 1/3 of the contract price. After
Right.
that, you know, the law is silent as to how the installments are made or constructed.
I don't know. I took the home improvement test and the contracting test, and it was 33 at start and 33 at completion. So, and I don't think there's been a change in the law, but that I'd like to get some more information on if you could get
Sure.
that to me. All right. Because it sounds like they could be cheating them 10%. And if it's wide open, they can say, give me 50% to start, or 50% for the contract. Give me 40% to start. Now they're only owed 10%. If they never show up, they got, you know, 90% of the money. And then it's going to be harder for the Home Improvement Commission to straighten that out. And that's all. Thank you.
Is there anyone else for Mr. O'Halloran? Seeing none, thank you very much.
Yep.
Sarah Price, Ms. Sarah Price.
Hi, good afternoon, Chairman Davis and honorable members of the committee. My name is Sarah Price, and I'm here on behalf of the Maryland Retailers Association. HB 395 makes positive progress towards allowing contractors to collect payment in a timely manner. Partial pay laws were written with consumer protection in mind, and now they have the unintended consequence of leaving contractors with little protection when facing customers who refuse to pay their balance. Allowing contractors to collect up to half of the agreed upon price up front will allow contracts to proceed more smoothly and will also have a positive impact on the cash flow of small businesses and independent contractors. I will note we have also proffered an amendment to the nearly identical HB 408 to allow the remaining balance to be collected when a project is substantially complete, which is defined as the point at which construction work is sufficiently complete that the owner may occupy or utilize the space. For instance, if a room is being redone and the floor has already been installed, the walls, the paint is dry on the walls, and all that's left to finish is replacing the outlet covers and switch plates, that would be considered substantially complete. So with that, thank you for your consideration, and we urge a favorable report on HB 395. Thank you.
Any questions for Ms. Price? Seeing none, thank you very much. That concludes our hearing on House Bill 395. I'd now like to go to House Bill 408, and that would be me. All right, guys, sit back a little bit. I want to walk back through this. This may take me a little bit to explain it. I'm sure you all have it, but I need to walk back through this for my own explanation, my own edification of what's going on. It was always my assumption, and it sounds like Delegate Impalaria, his might be slightly different from mine, but I always had the assumption that under current law, a contractor could collect 1/3 upfront and the rest would be after the job was completed, which is why I thought when Delegate Miller and then subsequently Delegate Adams were putting the bill in to make it 1/2, they were trying, and for the reasons they stated. I'm not sure if I totally agreed with the figure per se, but I understood where they were coming from. And I remember asking one of the witnesses in previous years, were they having a problem getting stiffed on jobs and things like that? And they told me yes. So, it was always just a matter of, could the committee come to an agreement on what the appropriate number was, that we weren't putting our constituents, our consumers at a competitive or at a disadvantage in that relationship, while recognizing that we also didn't want our businesses to run the risk of not getting what they were due. Let me fast forward to this summer. Like many of you, we had with everybody working at home, my wife decided that we needed to start revamping stuff in the house. So I got a brand new office and as well as carpet. And so I had spoke to a local retailer about putting in the carpet. And what happened was we sat down and picked it out and so forth. This was like on a Thursday. And then on that, and so I was ready to just pay for it all up front. And they were like, no, you can't do that. We'll call you in a couple days and we'll collect 1/3 of the payment, which was a Saturday. So I was like, oh, okay. And I was expecting, the job was supposed to be done that following Thursday. So I was expecting to pay the remaining 2/3 then. But that wasn't the case. They called me up Tuesday, 2-3 days after I gave them the initial deposit. Nothing else occurred between Saturday and Tuesday. And then they said, we're here to get the rest of the payment. And I had said, well, the job hasn't been done. It hasn't even been started. And they were like, well, that's our policy and so forth. So I didn't make a big deal of it because I was prepared to pay it all up front anyway. So we went ahead and did that. And after a while, I kept thinking about it. This subject kept coming up to me. And then, at that point, delegate kicked in, and I thought that they were violating the law, that, you can't collect it all up front. So I reached out to them and their representative, and I thought maybe it was something that wasn't quite right. And they assured me that it wasn't, that was a mistake, and they would get it corrected. And I found out they were still doing it. And so we had a conversation. And I think at that point, they went and spoke to their attorneys, and their attorneys told them, no, the way the law is written is that, and I mean, it's, I'll let someone with the legal background sort of get into the nuances of it. But essentially what they said was they could, under Maryland law, you can't collect any money at all prior to the I guess the signing of the contract. At the time of signing, you can collect 1/3, but there is nothing once you've executed the contract, at that point, the 1/3, there's nothing in the law that says from that point to the time that they start the work that they can't collect the remaining dollars. And I couldn't believe that. So I reached out to the Attorney General's office to verify it. And on July 15th, they sent me a letter going, yeah, that is the law. That's exactly the law, that they can, it's not that you can't get it until after the work is complete. It's the way it's written. It's just as I explained it. No money prior, I guess, to the signing of the contract. At the execution of it, you can get 1/3 at that point, but there is no fee schedule after that. So you can get the remaining money. In essence, you can get all 100% prior to putting a nail into the floor. So at that point, I thought one or two things happened. Either somebody wrote a very bad law or something else, because if that was the case, then there would never have been any need for the bill that former Delegate Miller brought before us. Why do you need to get the 50% or raise it from 33 to 50 or 33 to 100 or whatever, when all you had to do it was in phases, but you could ask for every dime of your money or that was due to you prior to putting one nail into the ground or one piece of carpet on the floor. All it did was saving you the inconvenience of having to get it maybe twice, as opposed to having to call Chairman Davis on Saturday and then call him back on Tuesday. You could just get it all on Saturday, which quite frankly, they might as well have done that. So what my bill, we're trying to bring this home, what my bill was initially saying, okay, I was trying to split the baby. You can get up to 50% up front, but you can't get the rest until it was completed. Yesterday, I had a conversation in a scenario that I hadn't envisioned. Quite frankly, I was thinking of much smaller projects, such as, the one I was doing. And I spoke with the Maryland Building Industry Association, and I think they're going to testify, Ms. McGrath and Mr. Enton, they're going to testify as well, and they can lay their scenario out better. And that made sense to me. They're signed up as favorable amendment. At this point, I'm ready to dump it on the subcommittee and let them work it all out and get it done. So that was my long-winded way of saying that there's some issues there on both sides. I certainly get where the industry, and my bill was never to call anybody a crook. I brought it in, once I saw what I believe to be the case with the law, that it was poorly written, but maybe it was done that way purposely. But in any event, I've spoken enough. At this point, I'll double back to Mr. O'Halloran, then Mr. Enton, then Ms. McGrath in that order, and we can go from there. I see Delegate Queen has a question. I don't know if it's for me. I can take it right now.
Yeah, thank you, Mr. Chair. My question sort of is to you, because I want to understand what your intent of the bill is. My understanding of how things operate is like what Delegate Impalario mentioned, and what I have experienced personally with working with contractors is that you put 1/3 down when you sign it, then maybe some days or whatever, they're ordering stuff, working on siding for my house, whatever it is. I give them another 1/3 when the job starts. So they give a target date of when that could be. And they get the ending 1/3 when work is done. And so before they've done any work, I've given them 66% of the money, because I've given them the 1/3 when we sign the contract, and then I give them the 1/3 when the job starts. So I'm not quite sure, again, as you gave your comment, I'm not quite sure what the law really says then, because that's what I thought it was. And so are you intending now that someone would give the contractor 50% at contract start or contract some time between the contract being signed and the work starting, which can be some time in between, especially if you're talking about things they have to order and all this stuff. And then the 50% remaining is going to happen when they kind of did the bulk of the work. So, maybe they've done the bulk of the job and I haven't done the final walkthrough. I'm trying to understand your intent, because I'm not sure.
No, I got you.
I'm not very happy yet. So
let me read this to you first. And this is a language from a letter the Attorney General's office sent me July 15 of 2020. A contractor may not demand any payment prior to the signing of the contract. That's under Business Regulation 8617A, and that they may not receive a deposit greater than 33% of the contract price at the time of execution of the home improvement contract. That's under Business Regulation 8617B. Now, here's the tricky part. Nothing in the language of either provision purports to regulate the schedule of payments once the contract has been executed, nor is there anything in the language that would provide a standard for when payments could be required. So what I'm saying is that as I understand this, and as we were told, prior to signing the contract, no money can be required. Once they sign the contract, I guess that's what they're calling execution, 33% can be required. However, that doesn't mean that's at that moment. However, before they put one nail in a board or anything like that, my reading is where it says, nor is there anything in the language that would provide a standard for when payments could be required. So what they're saying is that, and it seems like a fine line they're walking with that language. Yeah, at the time we execute or sign the contract, there's the 1/3. But just as it happened to me, this was a personal experience. We did the 1/3 on Saturday. 3 days later, but 2 days before they were to begin work, they called me and got the remaining 2/3. So effectively, I paid all 100% of my project, of my job, prior to any work being done. And I was told that was legal. And not only, I was told that by the Attorney General's office, and I was told that by the contractor. And so they were both together on that. So it's not, I mean, your experience could have been, and Delegate Impelari's, I don't know if that was like just the way they did business, 1/3, and then 1/3. That could have just been the way they did business. But the way this language that they've given to me, and this wasn't like a new opinion. This was based upon prior advice they had given on this subject. So it seems to be pretty consistent. The what actually required in the law is simply no money before the execution of the contract. At the execution of the contract is 1/3. And then after the execution point, at any point in time, they have the right to ask for whatever remains. That's my understanding. Now, the people behind me, they can come and tell me that I've misinterpreted or the advice that I've been given was wrong. And I will share this with the committee. I have it before me. It should be, I don't know if my written testimony was disseminated. If it is, it's in the 3rd paragraph. But if not, I'll make sure that you get it and you can see what they sent to me. But having said all that, Delegate Queen, the second part of what you asked, what I was intending to do, at this point, I'm intending to have the subcommittee work on it because I do want to, I know what I want to do for consumers. I'm also understanding the business aspect of it. And so I want to, I want to get this just right. It's more complicated than I guess what I anticipated, or there are nuances in it that I didn't anticipate. So it's something that I want the guys to take a look at and see if we can bridge some of that divide, because we just had the conversation yesterday. Prior to that, I thought I had it all figured out. So that's, that's sort of where I'm at.
Okay, thank you very much.
Did I see any other hands up? Delegate Impalaria? You're on mute, Delegate Impalaria.
Okay, we're unmuted. All right, so I worked for a window factory. We wrote the contract and took a 1/3 deposit right then and there. And you're right, the next day, we could have sent someone out to measure those windows. And as soon as that person measured the windows, that was considered starting the job, and he collected the other third. And then the last third was paid when the job was done. That's the way the company did it because we believe that was the way the law was supposed to be. What you're saying is there's a timetable, but the timetable only has 12 o'clock and it doesn't have any hours after that in reality, because what he could do under the way the Attorney General has described it, you write the contract, give me 33%. He gets up, he steps out of the chair, he walks around the circle, he sits back down in the chair and says, now give me the rest of the money. And that's exactly would be the interpretation if we're going to stand in front of a judge. And if that's the way the Attorney General sees it, that's the way that doesn't make any sense to me. Now we need to maneuver this.
And that hence the bill. Yeah.
Right. And if we need to maneuver this, that it changes from 33 1/3% that they can collect 40 or 45 and they have an outstanding amount left over of 20% or something like that, I would be good with that. And look, I'm speaking from experience. I've done this for a living and I understand why we need to protect the public, because there's a lot of unscrupulous people. If you want to do some history on this, watch the movie with Danny DeVito, The Tin Man, where they were basically writing contracts and stealing the money. So, and give me the money, and then they never would show up to put the aluminum siding up. That's what has a home. The whole movie is about Maryland and the Home Improvement Commission. That's what it's about. So I can't believe that somebody wrote a bill, as you described, that horrible, because that is a timetable with no time but the starting time. And that makes no sense. So I've said my piece.
And I agree with you 100%. I use those exact words. I talked to Delegate Wilson over the summer and I was like, can you believe this? Somebody screwed this up that bad? So like I said, I could have gotten something wrong. And at this point, I want the guys to take a look at it to see whatever, I'm not married to any particular language, but just Delegate Impalaria, you and I think have the same feeling about the bill. If what I'm told is correct, if my interpretation is correct, it is ridiculous. That you're literally right. After they do that, maybe they wait till the next day to make sure that there isn't a problem. But like I said, I paid 100% for my project, not when they just came and measured, before they left the shop, 100% was paid. It was just basically in 2 installments.
Right. So, and Delegate Queen is on the same page with us. So we should note this day, and homework for the night is watch the movie, The Tin Man, with Danny, whatever his name is, and watch that movie, because it is about Maryland history and it is about the Home Improvement Commission, and it'll explain some of this to you.
You got it. Yeah. Any other members have any additional questions for me?
Mr. Chairman, I just wanted to ask if Delegate Impalaria is in the movie.
Yes, I am.
All righty. All right, with that, let me switch over now and go to Mike O'Halloran.
All righty. Thank you, Mr. Chairman. Again, for the record, Mike O'Halloran, State Director for NFIB Maryland. I appreciate you bringing this bill forward. I certainly am sorry to hear about the experience that you had. I certainly hope they were not an NFIB member. But among your remarks, you talked about setting some sort of standard. And as you can probably understand from my written testimony, that's kind of tricky to do across such a broad spectrum of an industry. For instance, I'll use home builders. These are large scale projects, and with large scale projects come a large amount of money. So, under your bill as introduced, if they were to, and actually you can look on the fiscal note under the small business effect, it kind of speaks to this as well. But under your bill, if I were to say, ask for an initial deposit of 33%, keep it easy numbers, on a $100,000 job. So you pay me $33,000 under your bill as introduced, I would not be able to collect the remaining $67,000 until the job is complete. Now that obviously creates a huge and significant cash flow problem for me. So hopefully there is some wiggle room. My testimony, the amendment is basically to strip the language on page 2, lines 1 through 3, and make it identical to Delegate Adams. But again, I look forward to working with the subcommittee. I think it's, at the end of the day, while the Attorney General is correct, and Mr. Chairman, you are correct that, the day after the execution of a contract, a contractor could ask for the rest of their money without doing a single day's work. At the same time, I believe that we as consumers should also take the time to read that contract and make sure that it's up to, what we are comfortable with. And you also, as a consumer, have the right to look at your contractor and say, no, you haven't lifted a hammer. You haven't put a nail in the ground. I'm not paying you another dime until you start working on this job. So I think, the committee should certainly keep that in mind as we move forward in this discussion and try and figure out, in your words, a sweet spot. So again, I appreciate it and look forward to working with the subcommittee and the full committee.
Thank you. Delegate Wilson?
Thank you, Mr. Chair. Can you hear me?
Yep.
Mr. Chair, I just want to say that multiple times I've experienced the same issues that you're discussing now, mostly with larger stores such as the Home Depots and the Lowe's getting installations done. And as we talked about, the way the bill is written is exactly what the problem is, because I have never been charged anything less than the entire amount of an installation, regardless of whether I was going to like the outcome or not. And I do believe that, I'm glad you're passing this on to the work group. The work group in my subcommittee to deal with, because it is an issue. And I believe that by them drafting, or the request that they had through Delegate Miller's bill, is that it did bring this issue up, that they're not following protocol. If the spirit of the law says one thing, the letter of the law definitely said something else, as you found out through the Attorney General. So I kind of disagree a little bit with Delegate Impalaria, because that is the way the bill's drafted. It allows them to ask for 100%. And most of these stores, because I've asked many individuals, most of these stores repeatedly get 100% of the installation fee prior to lifting a finger. So I definitely look forward to having my committee work with this and make sure we have something that is much more protecting of our constituents. Thank you.
Anyone else for Mr. O'Halloran? If not.
Yeah, Chairman, I do, Ben.
Delegate Brooks?
Yeah, Mr. O'Halloran, what about, you were talking about the cash flow problem. What about the contractor establishing a relationship with a bank?
Oh, absolutely. I mean, I understand the idea of a relationship with a bank. At the same time, they're dealing with distributors, sometimes multiple distributors. They're also dealing with subcontractors. So it's I appreciate what you're saying working with the bank, but for instance, I could have a flooring distributor that he only takes cash money. So it's a good point, but and I think Delegate Wilson also kind of alluded to a bill that former Delegate Miller had about putting down a surety bond. That may work for larger big box stores, but for the small mom and pop contractor, to try and put up that amount of money to secure a bond, that's problematic as well. So the idea of cash flow is a very serious issue with contractors. So that's again, I look forward to working with the subcommittee, because we also want to make sure that our smaller contractors are not at a disadvantage.
Yeah, because my concern here is that you've taken all of the leverage away from the homeowner, and then there are some shady guys out there, and I've experienced that. So yeah,
Sure.
yeah. So, but that's,
And I appreciate that, Delegate Brooks,
Yeah.
and I'm sure all of us have had, whether not just the construction industry, but any industry, you've had to come up against some unscrupulous characters. But, as with Delegate Adams' bill, as with the chairman's bill, the consumer still has, the right to redress with the Maryland Home Improvement Commission, with the Attorney General's office. We're not changing that at all. And one thing I wish I had done is to reach out to both of them and see, over the last 5 years, how many complaints they've had, with regards to, the issues that unfortunately the chairman went up against.
okay, all right. All right, thank you. Thanks, Chairman.
Thank you. Anyone else? Oh, and by the way, guys, at the conclusion of this hearing, please stay on. I got an important announcement to make as well. Let me move on to Robert Enton.
Thank you, Mr. Chairman. Can you hear me?
I can.
Very good. Thank you very much. Robert Etton on behalf of the Maryland Building Industry Association. We are favorable with amendments. I want to thank the chairman for a Zoom meeting we had yesterday, myself and Lori Graff, who's the president of the association, and the chairman, to talk about this. And we are signed up favorable with amendments. We certainly recognize the issue. I had no idea that's what the law did. I think anybody would read that law and probably think that you got to put a third up at the time you sign the contract, and then you're going to, pay the rest, at some point in the future, after the work is started. So we don't have a problem with trying to deal with this. One of the points that we raised to the chairman, and I think you heard it, but this is, this impacts our members. Our members are contractors. Most of them are small businesses. And they might do a remodeling job. They might do a kitchen remodel. They could do a roof, whatever it is. They've got to, put the money out. They've got to pay wages. And I think the main thing that concerned me when I looked at it, and I don't think it's just, as the chairman said, we had a good discussion. There were things that I didn't thought about and that he hadn't thought about. Let's say that I've got a $10,000 contract to do a kitchen remodel, and everything is done except for the fact that for the kitchen cabinets, the hardware to open the kitchen cabinets hasn't come yet, or the garbage disposal hasn't come yet. So the job's, quote, not complete, unquote. Yet that $10,000 contract for labor and materials, I've had been billed and had to spend every dime. I got a new gas range this summer, and it took 69 to, I guess, 67 days, whatever, for the gas range to come. So I think the key is to try to figure out what is the right criteria for what gets paid when and how does it go. One possibility is to have a minimum amount, say that for an amount under X number of dollars, then you get half and you get the other half when it's finished. Or to have a statutory schedule, a third, and a third. Or to say that it's, I think the retailer suggested that you can get paid when the job is substantially complete. So I think everybody, at least for our industry, and I know in talking with the retailers earlier today, everybody believes that this can be worked out to make sure that consumers are protected, and at the same time that the businesses are protected as well. I don't think it'll be a problem. We look forward to resolving the issue. Thank you.
Yep. Any questions for Mr. Enton?
Mr. Chairman, can I ask a
Yes,
question?
sir.
Yeah.
Yep.
So the bill that the chairman has is a bill, Bob, that I would support. It's a policy that fits for the kind of business that we're in. And in fact, most upstanding contractors normally do apply the principle that we'll collect the balance when the work's done, or at the minimum, we'll collect the balance when we're there to do the work. Now, if you've got a large job, and I think this is where your industry kind of throws the challenge on the chairman's bill, which is, we're not talking about $5,000, $6,000 contracts in your world. We're probably talking about $50,000 or $60,000 contracts. And, to one of the other delegates' point, there's no bank unless you can get a 3 $100,000 line of credit. There's no bank that's going to help float, cash flow, nor should you really use lines of credit to float cash flow. You use lines of credit to buy materials, in some cases collect a discount on material, and that's a business exercise behind the line. It's not meant to cover your life existence as a business owner. That's the bank's role is a completely different role. And so the chairman's bill I like because it's prescriptive to the challenge that's facing the contractors, which is our costs are going up. 2x4s and plywood. I'll simply say to you, I'm not in the industry of construction, but in the past 3 or 4 months, the cost of wood has gone up double. I mean, simply double the cost. Contractors that have already entered into agreements with homeowners, they have to own that cost expense. And so all I'm saying is that the chairman's bill absolutely gets to it from a business perspective. The concern I have, and this is the question I have for you, Bob, is that when the Attorney General in their rightful position to protect the consumer is trying to do that, I don't think an unscrupulous contractor cares one iota about the MHIC license, the rules that relate to it. And so at the end of the day, if you've got a contractor that doesn't respect the consumer, I'm not sure that the MHIC has enough wherewithal to change the contractor's behavior. What MHIC can do and should always do is protect property owners during the worst case scenario, which is they get completely left out in the cold. But the question I have for you is this bill doesn't really speak to your industry because the dollar amounts are significantly different than a small remodeling contract like a painting job or a floor covering job, which gets done in a few days, right?
So Delegate Adams, the bill doesn't have any dollar thresholds that would apply to all home improvement contracts. So that's going to be a $700 carpet for a bedroom, or it's going to be a $70,000 remodel for 3 rooms in somebody's house. So I think that's one of the things we have to kind of try to work through. What should apply when and to whom. I was glad to hear that there is no, it's not a situation where the contractors have, any people believe contractors have done anything wrong. That we, once again, our people are remodelers or builders. And I feel really certain that we could sit down and have some time to talk. That we'll come up with something that's fair to retailers, fair to contractors, and also fair to the consumer.
Thank you.
I don't see why we can't solve this problem.
Yeah. Thank you, Mr. Chairman.
And I just want to be clear, I'm not accusing the industry of any wrongdoing. That wasn't my point. It was more of an intellectual thing. Once one of the hazards of being in this job, and you start hearing all these bills, then you go out and have like a real world experience. And so you start thinking back, or maybe I just need to get a life. But I started committee hearings and I put it all together. So it wasn't this is not an indictment on our, on the industry. Please, I don't want anybody to say I'm calling them a crooks or anything like that.
I didn't mean to imply that at all, Mr. Chairman.
Yeah, no, but I just wanted to be clear. I was just like I said, the law as it was explained to me versus what I thought our interpretation of it based upon prior hearings didn't match up. And so anyway, I've talked enough. Let's hear from the new delegate, Delegate Pippy.
All right. Thank you, Mr. Chairman. So just 2 very brief points. The first one is, as the law is currently written, I agree with the chairman that there's really nothing preventing a contractor from calling you back 10 minutes later and collecting the remaining balance, because they could argue that wasn't part of the initial deposit at the time. And so that probably needs to be fixed to some extent. The question that I had, historically, using the home building as an example was always the rule of 3, where, materials cost a third, labor was a third, and then in a perfect world, there would be profit of a third. So my specific question would be kind of what Mr. Enton said was that this is assuming that the cost of materials is somewhat similar. And so I would imagine these contractors would want at least the initial deposit to cover the cost of materials, because this is something that they have to pay for out of pocket. And I just want to know, I mean, is there a figure that would cover that? I mean, is 1/2 enough to cover all of the cost of materials in today's economy? And so if maybe Mr. Enton or Mr. O'Halloran could just address that piece, because I would imagine that's the most pressing issue, especially on cash flow. So thank you.
Yeah, I really can't say. I mean, you know, I know that to me, what I've seen personally over the interim is that just like the chairman said, he's in his house all summer working remotely, and you become much more aware of what needs to be done at your house. So I think that contractors are in very high demand, and supplies, particularly, you know, furniture, but appliances are in very, very high demand. And, you know, in the economic world, you know, demand is what is, the higher the demand, the higher the price. Now, I don't know that that's, you know, I think there's still tremendous competition if you're going to, you know, out there in the marketplace, but it's been tough. I don't, you know, we'd be happy to have some of our contractors, you know, be involved in this and kind of talk to you about, you know, how things work. And I think a lot depends on what the job is. You know, the home improvement contract statute is very, very broad. I mean, it covers, and I asked about this today, I think it covers the big hardware stores. It covers the national building industry in many respects, and it covers the guy that works on his own and maybe has one employee or two employees. So it's pretty hard to say, Delegate. But I think we can come up with something that is fair to everyone. I don't think it'll be a problem, really.
Yeah, Delegate Pippy, very quickly. I mean, I go back to my previous statement, is that it's kind of tricky to find those standards, to Bob's point, because the home improvement law is so vast, just like the types of contractors. I mean, if I'm just like Delegate Adams, if I just do floors, my materials are going to be wildly different than if I run a kitchen restoration company, where I come in and I put in your nice, you know, farm sink. I mean, it's apples to oranges. So that's why I think, you know, once we start talking with the subcommittee and working through that process, I think we may be able to find something that perhaps is, you know, you have to, you know, as a contractor, you cannot ask for, let's say, the final 25% or 15% of a contract until the work is completed. Perhaps something like that, as opposed to dollar amounts.
Yeah. Mr. Chairman, I'm up on another committee. Can I be excused, please?
Yes, sir.
Thank you very much.
Take it easy, Bob.
Thank you.
Let's wrap up with Lori Graff. I believe she'll be able to help us out a little bit. And like I said, we'll send it to subcommittee and go from there.
Mr. Chairman, Delegate Walker has a question too.
Delegate Walker.
Thank you. I just want to know, in your bill, and this kind of goes for you, I guess, Derek, the chair, as well as the people there, like what Mr. O'Halloran just said, to me, that's my biggest concern. Like as a consumer, that last 25%, like the most frustrating part of a renovation is when they say it's going to be done on this time and, oh, we're just waiting for these last parts, or we need you to touch up some paint here, pull this stuff that they say they'll do that are little things. Will your bill help the consumer in that aspect in terms of giving some protection to making sure the job is complete?
I think it's drafted. It most definitely would have, because it would essentially hold off 67% or 2/3 of the payment until after it was complete. I think at this point, the prudent thing though is for you all to take a look at it. Let BR take a look at it and try to figure out what's the appropriate balance. I think certainly for the larger contracts, it's probably more detailed, more nuanced than what I looked at. I think for the smaller projects, such as the one I was doing and so forth, I think it's probably definitely more appropriate. But at this point in time, I'm not committed to just, you know, my specific language. if you guys think and working with, working with the advocates that there's a way we can tweak it to make it better, I'm all for it. So I'm not pushing. What I'm trying to say is I'm not married to any specific language. I want a good public policy, one that's, reflective of both sides and put neither at a disadvantage. Now, that may be asking a lot, but I want some other input in this. I want your contributions and the subcommittees, and see what we can come up with. I just don't think, I guess where I'm really coming from is what I saw was on the books. I didn't think that was appropriate. And so now this is a stab at trying to improve upon current law.
Gotcha. Thank you.
If there are no other questions for me, let's go to Ms. Graff. I don't know why I keep saying
Good afternoon, Mr. Chair and members of the committee. I'm Lori Graff. I'm CEO of the Maryland Building Industry Association. I think most of it's been covered. And thank you again, Mr. Chair, for taking the time to meet with us yesterday. When I saw this bill, my head immediately went to the bigger projects. We represent a lot of remodelers. They're doing full kitchen remodels. They're doing, large scale remodels. So to not get half of what half of the contract until the very end can be problematic for cash flow, as Mr. O'Hallahan mentioned. So I did call some of our remodelers just to get some perspective from them. I think what a lot of you mentioned earlier is that a third is what's really being done in practice quite a bit, especially on these larger projects. Not so much maybe the carpets or the windows, but for the larger projects, they're certainly doing a draw schedule. They certainly have a contract that has a draw schedule in it. And they're operating at this point, especially with the cost of materials, at about a 5% margin. So just between labor and material. So that is challenging to not be able to get 50% or 75% until the end of the project. That really does hurt cash flow. And most of these remodelers are small businesses. And again, I wasn't thinking more on the lines of the carpet or the windows. I was thinking more of the actual larger projects. So I think we can certainly come up with something. We had talked about a threshold. We had also talked about maybe some language dealing with the draw schedule or something like that. So we're happy to work on it and try to figure out a solution that works for both the consumer and the small businesses. Thank you.
Any questions from Ms. Graff? I guess we wore them all out and you get the easy one. Thank you. Thank you, Lori. Are we sure? That was our final witness on the bill. We have some written testimony as well. Again, I guess to be redundant, we're going to take a look at this and we'll give it our best shot. And I know I'm confident we'll come up with something that's fair and equitable to all parties. I thank you all, everyone, for indulging this. I know we thought this was probably going to move a little quicker than it did, but I must say I did enjoy the conversation and certainly hearing everyone's perspective, what sort of practice versus industry practice versus the law. So we'll get this done. And with that, I would to those that were here for 408 and for 395, you can be excused. Members, if you can just hang on, I was asked to share some information with you. If you give me just a second. Of course, I'm not going to be able to find it now, but let me see. Here we go. If for those that are assigned to the annex, and if you are on the Annapolis complex today, you must go to the annex to have your voting system security verified. You must do this in person. If you're not on campus and have not done so this week, reach out to the speaker's office and they'll make other arrangements. So if you're in Annapolis and you're in the annex, you need to go over to the annex and get the voting system security verified. I have no idea what that means, but you need to do it. Okay.
Mr. Chairman?
Yes.
Is there a timeline like till 5, or is it till?
I'm assuming it's till 5. We haven't
Okay.
been given any,
It was 1 to 4. It was
1 to 4?
4.
Okay,
Yeah,
so
yeah,
we still have
Wednesday,
an hour
Thursday,
and a half
Friday.
before then.
Yeah, you have to
Okay.
get your fingerprint to put on your personal iPad, iMac they're giving you to vote. So it takes about 3 minutes. It's simple, but
Okay.
that's just,
Either that or the chairman gets to vote for you. So that's it. Listen, everybody, have a great weekend. We are off and running. We don't have anything Monday. I believe the calendar for us is empty, so you can do your constituent work. But bill hearings in earnest starting Tuesday. We'll be off and running. So thank you very much for your indulgence. Stay safe and have a great weekend.
all right, be safe.